Hi, my name is Princess Solomon. I'm the coordinator of International Student Admissions. In my office, it's myself and my assistant, Zanita Evans. So if I'm not available, please feel free to give her a call. She would assist you in any way. And if she's unable to do that, then she will refer you to me. So today we're going to talk about F1 students and enrolling at Wake Technical Community College. We just want to start out to let you know that all non-native English-speaking students are not international students, and all international students are not non-native speaking English-speaking students. So you have students here in the U.S. that are non-native English-speaking, but they're not international students. So you can have U.S. citizens, permanent residents, you can have students on other type of visas where English is their second language. However, they're not an international student, okay? The other scenario is you may have someone that's an international student, but English is that student's first language because that's the language of the country. So just keep that in mind. Sorry. All right. So for the international office, when I say international students, I am referring to students who are here in the U.S. on F1 visas. If the student is here and the student is a U.S. citizen or permanent resident, but completed high school or college outside the U.S., I do not consider that student an international student because he or she is a U.S. citizen, a permanent resident, so they're not an international student just because they completed their education outside the U.S. But for our office, international students are students who are here for the purpose of studying and their intent is to return to their home country. In the international office, we issue I-20s. This is a government document that we issue on the behalf of the government. And when we issue this I-20 to a student, we're letting the government know that that student met all the admission requirements for our college and he or she has the permission from us to come and study. Every international student needs this I-20 to go to the embassy and apply for that F1 visa to be able to come here to the U.S. to study. So they cannot go to the embassy saying, I want a student visa without an I-20 from an institution. So whatever school they want to attend has to issue them an I-20 in order for that student to go to the embassy and apply for a student visa, which is the F1 visa. Right now at Wake Tech, we currently have 270 active F1 students from 71 different countries. When it comes to knowing who should fill out the international student application packet and who shouldn't, there's a list of questions. And so I have this in the PowerPoint and I'll also have the sheet you can look over if you want to look over that. But normally if the person's a U.S. citizen or a permanent resident, they would do regular admissions application. If the person is on a visa, there are many different types of visas. The most common one that the student will have and they would need to see me is a tourist visa. So if the student is here in the U.S. on a tourist visa, he or she needs to come see me. The reason for that is because immigration does not allow that student to study in the U.S. on the tourist visa. That visa was given to tour, not to study. Mainly all the other visas the student can enroll. There's some exceptions to some of them. So if you ever have a student that comes to you and wants to enroll and he or she says they're on a visa, then you can always contact our office and we'll ask what's the student's immigration status and then let you know if it's regular admissions or if the student needs to see me in order to apply for a change of status with immigration.
I understand all this connects to the curriculum instruction for continuing education instruction.
Doesn't matter. Right, so your question is for continuing education courses, does it matter what the student's immigration status is? And the answer to that is no. So if I have a student that comes to me and he or she's on a tourist visa or F2 visa, which is a dependent of an F1 student, Those two visas, the students are not allowed to study. So if the student does not want to change his or her status, then I'll tell the student, you can take non-credit courses through our continuing education department, and you would be okay with immigration. However, at the end of the day, if the student is going to go back and forth with me about it, then I'll let the student enroll in the curriculum course, but I warn that student that you're violating your immigration status. And I would let them enroll because we're an open door school. However, I would probably put holes on that student's record for when their current immigration status paperwork expires. Because at that point, you have to prove to me that you filed an extension with immigration and you're still legally in the U.S. But yes, they can do non-credit courses through the continuing education department, and it doesn't matter what the student status is.
But you have to be legal in order to take curriculum courses.
Yes, legal and depending on what your immigration status is.
If you're here illegally, you cannot take a course that would affect it.
Okay, we can go ahead and talk about that. So if you are here undocumented, okay, you have to have graduated from a U.S. high school, public school, homeschool, or receive an adult high school diploma. If you are undocumented and you graduated from high school outside the U.S., you cannot attend Wake Tech. Correct. When it comes to non-credit, it doesn't matter really about your status. I'm talking about curriculum because non-continuing education, it really doesn't matter. I really don't know what the policy is. I don't know if continuing education has it. I am going to say it would be a no, but I don't know how they check it because that policy is a North Carolina Community College policy, not a Wake Tech policy. So I would think that it's supposed to be for non-continuing course, continuing education courses too, but I'm not too sure how they're able to monitor it with their registration form. I don't know if they have a question that asks that or not, but if you did not graduate from a U.S. high school, private school, or homeschool, or receive the adult high school diploma, then you're not supposed to attend the North Carolina Community College. So if the person is undocumented and has a GED, unfortunately that doesn't qualify. It has to be an adult high school diploma. Now, with that being said, you have a category of undocumented that are approved for deferred of action. I don't know if you heard of it, but it's consideration of deferred of action for childhood arrivals. If the student has been approved for deferred of action, the student has to submit paperwork to me showing that immigration has approved them for this, and that student can enroll during the regular registration period, regardless of what the education is. So you have two different sets of undocumented.
You got a confusing job, don't you?
Yes, yes. And that status, what that status is it does not give them legal status or lawful status. It gives them lawful presence. So that means for that duration of that time, which is 2 years, they can work here in the U.S. and they can stay in the U.S. and not gain unlawful presence. But this does not lead to citizenship. It does not lead to legal status. So while they're here during that time, they are able to enroll during the regular registration periods, but they have to go through me and submit documentation to me for me to lift the hold for them to do that. And their tuition is out-of-state tuition.
And that's for the F1?
No, that's for undocumented who have been approved for deferred action. So there's certain documentation that immigration gives them that shows they are approved for that period of time, and they have to show that to me.
How long can a student be here on an F1 visa to study?
As long as that student is maintaining his or her immigration status, it doesn't matter. And then I'm going to get to that because that's one of my duties is I have to monitor these students while they're here. They have to make sure that they enroll as a full-time student, and they have to make sure that they're making progress towards completion. And so that's something that I review when their I-20 is about to expire. And so it's kind of like that's when it gets checked. Did I confuse anybody about the undocumented, documented part? No, okay. And for undocumented students versus the undocumented or DACA, their tuition is out-of-state tuition. They do not qualify for in-state tuition. For students that are deferred of action because they have the ability to work, if their employer sponsors their tuition and pays their tuition each semester, then the employer would be charged the in-state rate, but not the student. Okay. For the undocumented students, if they meet the qualification of graduate from a U.S. high school, homeschool, private school, or have an adult high school diploma, as long as I have their official transcript, they have to come see me to register for their courses. And they register on the day after the drop add period. So they have missed the first week of courses and they only left with what's available. They have to register with me at 8 o'clock that morning. They have to start going to class that morning and pay their full out-of-state tuition that same day.
So, to clarify, we're requiring someone who's not a U.S. citizen, who doesn't speak the language, to register for a class and start the class a week after everybody else has started, and take a full load.
No. So these students are students who's been here their whole life. They've probably been here since they've won. And they speak. No, these are the undocumented students who's the only thing they know is the U.S. It's just they're undocumented. They weren't born here. So they speak English. They went through the school system and everything, but they're not legally here in the U.S. And so unfortunately, you know, they graduated from Carey High School and they're not legal. So and they don't qualify for deferred action, either because of when they arrived in the U.S., because they went back home at some point in time. It's something off that list that they didn't meet, where they don't qualify for deferred action. So those group of students, they come see me on the day after the drop add. I register them in whatever's available according to what they need. They pay the out-of-state rate. They go to class that day, and they've missed a week. However, I'll let SEVP Brian Ryan know who these students are with their schedule, and they contact the instructors, and the instructors know not to count the absence against them. But we have about 5 students that faithfully come every semester. The rest of the students have been approved for deferred action, so they don't fall under this anymore. All right, so we have ESL and EFL, English as a foreign language and English as a second language. There is a difference. With the English as a foreign language, this is the program that we issue an I-20 for. So this is the program that we will give a student an I-20 to apply for a student visa and come here to the U.S. to study. We do not issue I-20s for our ESL program. The difference between the two is EFL, English as a foreign language, is ran through the curriculum department. Once again, it qualifies for an I-20, and it has 4 different levels. You have listening, speaking, reading, grammar, and composition. And then composition has a 5th level. So these courses are set up to prepare the students to be ready for English 111 and college level courses. It follows the semester calendar, and tuition applies to those courses. English as a second language is ran through the continuing education department. We do not issue I-20s for the English as a second language program. There are 6 different levels. These courses are held out in the community, and they're free of charge. So if I have someone that's here in the U.S. on a tourist visa, and he or she doesn't want to change his or her status, but they want to study English, I refer them to ESL, English as a second language. Because if that person wants to study English as a foreign language, we have to go through immigration to see if they approve it or not.
Princess, if the student then changes from a tourist visa to a F1, could they come back and do the ESL program?
No. If I issue an I-20, you have to take English as a foreign language.
Okay.
So they can do the English as a foreign language. I do not allow the students to do English as a second language with the I-20. For the international office, for the F1 I-20, we have 3 different deadlines for each semester. So by this date, I have to have the application and all the required documents for the student in order to issue the student an I-20 for that particular semester. In the application packet, it includes the application. We do have a $40 application fee. The application fee is only the international student application, not regular admissions, okay? We have to get financial documentation, educational documents, medical form, and an I-20 mail-in option form. And I'm going to go over these. All right, so the application basically just lets me know their demographical information, educational information, so that we can key them into the system. $40 application fee has to be paid with a cashier's check or a money order payable to Wake Tech, but we do not accept cash. If there is a local contact here in the U.S., that person can come in the office with his or her personal check and pay the $40 application fee. Financial documentation. This is an immigration requirement. So for every student, he or she has to submit documentation showing that someone has at least $23,300 US in their bank account. If the student has it in her or his account, then they supply me with a bank letter on letterhead stating the date of the letter, the person's name, the current balance in the account. If the student does not have sufficient funds, then that student has to have a sponsor. So that can be a family member, a friend, the person can be in the U.S., outside the U.S., it doesn't matter. But that person will submit the same letter along with a notarized affidavit of support form. And on that form, basically the person is saying that I'm going to provide all educational and living expenses for this student while he or she is in the U.S. studying. Now, we have students who have a spouse or children that want to come with them to the U.S., and that's fine. And so we have to issue dependent I-20s. So for a spouse to receive a dependent I-20 is an extra $5,000 in the account, and for every child is an extra $2,000 in the account. The reason this is a requirement for immigration is because that student has to prove to immigration that he or she can come here and live in this area and study full-time and be taken care of. The students cannot work. They can't just go out and find a job. So immigration wants to know that the student is going to be okay while he or she is here in the U.S. Residency classification. So for the F1 students, they pay out-of-state tuition. No matter how long they've been here in the U.S., their tuition is out-of-state. Okay. Now you have other classifications. Let me go right here. You have other classifications that pay in-state and out-of-state tuition. So for U.S. citizens, permanent residents, if they've been in North Carolina for at least 12 months, they pay in-state. If they haven't, then of course they have to meet the 12 months and then do a residency application. Refugees, asylees automatically get in-state tuition, no matter how long they've been in the U.S. So they could have just showed up yesterday. They automatically get in-state tuition. You have some visa categories that only if they enroll, it would be out-of-state tuition. And then you have some categories that could possibly be in-state. They have to fill out the residency application, turn it into the registrar's office, and the registrar's office will determine if they qualify for in-state or not. I want to go back. The $23,300 US, this was just a breakdown of the chart to show how we came up with that figure because we have to show immigration. So you have the out-of-state tuition at the max tuition rate per semester, books and supplies, which I know is probably underestimated, living expenses, and medical insurance. So that's how we came to that number.
That's institutional dependent though, right? I mean, if you went to a more expensive school, that would be
much higher, right. Oh, this clicker doesn't like me. Okay. Yeah, because I don't know if they're... Okay, for the educational documents, certain countries have certain educational documents. So it's not as easy as a transcript because in other countries, the transcript may not show completion or a graduation date. In certain countries, just because you've completed 12th grade does not mean you completed high school. For instance, West African countries, you need your WIAC, West African Exam Council certificate. So in certain countries, once you finish 12th grade, you have to go sit for an examination, and your results from the examination determines whether you completed secondary education or not. I know a lot of the countries, like for instance, when admissions here get educational documents, they scan and email it to me and say, can we accept it? North Campus does the same. But if it's not a country that requires examination after high school, then we would take the transcript. There are certain certain different types of diplomas that require for certain countries, but what I'm looking for is that particular document that that country calls for to show completion of secondary education. If the student has a document and is not in English, we will need a translation. We have a list of translators on our international website, or the student can simply look in the yellow pages under translator and have anybody translate it. The student would bring in the original document with the original translation. We make photocopies and give the original documents back. So this is just a list. There's a difference between translators and foreign evaluators. So if a student has a document that I know is what I need, but it's not in English, I only ask for a translation. I do not ask a student for an evaluation. So I know sometimes someone would say, well, have this evaluated, thinking the evaluation and translation means the same. It's different, and it costs different. I ask the students to translate their documents first, and if I review that translation and it doesn't tell me what I need it to say, or I'm asking the student for a particular document that I know I need and the student's saying I don't have it, then I say take your educational documents that you have and have it evaluated, because this costs like $250. And what the agency does is they look at all the documents, they evaluate it, and they give you a report to let you know what it's equivalent to here in the US. But that's kind of a last result because it costs us a lot. So normally I only need a translation. Oh, you can go ahead. Yeah, sorry.
Are you doing this for employees as well? Or do you
The translations?
Yeah.
No. The HR, you mean Wait Tech employees?
Yeah, if we hire somebody who's got international transcripts.
No, the HR department has a list of specific evaluators that they have the employees go to and have their documents evaluated. But I think we're working off the same list. I think we got together and have the same list. Medical form. We do have a medical form in the international office. The most important part on the medical form is a TB test. We have to see a TB test within the last 12 months, and if it's positive, checks X-ray results. You can go ahead. I-20 mail-in option form. This is basically just a form for the student to tell me how I'm going to get the I-20 to the student. We have 4 different options. We can send it through regular postal mail that takes up to 6 weeks. We have an express mail option that we use eShip Global for. And what happens is the student goes to eShip Global's website, set up an account, choose what company they want to do the express mail option with, and pay eShip Global directly. And then I go in and print the pre-shipping label, and we send it off, and the student can receive it in 3 to 5 business days. Another option is we can mail it to a local contact here in the US through regular postal mail. And then the last option is for the student or a local contact to come in our office and pick up the I-20. And then that person will FedEx it to the student. Okay. So our application packet is located on our international website, which is international.waittech.edu. We have a lot of information there, so you can always refer the students to the website or have them call me. We do not accept documents via email or fax. We do have to have the original documents either sent to our office by mail, or someone can bring the documents into our office. For regular admissions, for all of the applications now that are not U.S. citizens or permanent residents, I receive their application. If I go through it and the immigration status part of their application is questionable, I contact the student for verification. Or if an F1 student does an online application, which happens sometimes, they're referred to me because our F1 students have to do a paper application. Okay. This just goes over the process of F1, meaning they first apply to the institution. Once the application is complete, I mail out an I-20 to the student. Once the student receives the I-20, he or she contacts the American Embassy in his or her home country to apply for the F1 visa. They find out exactly what's needed for that appointment. They go there, they apply. If the F1 visa is granted, because at the end of the day, it's the embassy's decision whether they issue the I-20 or not. Just because we issue the visa or not. Just because we send the student an I-20 does not guarantee that the embassy will give them the visa to come and study. They have to show the embassy that they have the financial ability to be here to study, and that they have the intent to come and study and return home. If the embassy thinks that that student is going to come here and not return home, they would deny the visa. So a lot of times if the student cannot show that he or she has strong ties to his or her home country, it may cause a denial of the visa. Okay. All right. These are just some samples of the immigration documents that we have. This is the I-94, the approval notice from immigration. So if a student applies for a change of status here in the U.S., they will receive this approval notice if immigration approves it. Here's a sample of the I-20 that we issue at our office. You have, this is the entry stamp. Whenever someone enters the U.S. or you enter in another country, your passport is going to get stamped, and it states what your status is. Next to that, you have the visa and passport, and then your I-94. The I-94 used to be a paper I-94, but now everything is electronic. You have a few people who get paper I-94s, but now they pretty much going to the electronic online I-94. I-94 is a arrival departure card. So anyone who comes in the U.S. That is not a U.S. citizen or permanent resident, you have a arrival departure card. And that lets you know you're in and out of the U.S., the dates, the times, the dates and what your status is. So a lot of times if I have someone with a questionable application, I'm going to ask for their I-94, their visa, and their passport, and that entry stamp, because all of those documents tells me what your immigration status here in the U.S., and it tells me how long you are able to be here in the U.S. Okay. For the placement test, a lot of times you wonder, should the student take the EFL placement test or the regular AccuPlacer placement test? And normally if a student's English is the student's second language, we give them the EFL placement test, just to make sure he or she does not need the EFL courses. If you have a student that completed high school here in the U.S., what I ask is, did you take regular English courses or did you take ESL type English courses? If the student completed regular English courses and was very successful, then they take the regular AccuPlacer. But if they took ESL type English courses in the high school, then we still give them the EFL placement test. By them having the EFL placement test, it doesn't hinder them. What happens is that test is meant for students where English is their second language. So they could place out of remedial courses in the EFL placement test better than they could on AccuPlacer if English is their second language. It's just going to roll over into the regular Compass reading and writing, so it won't just stop the student. We do not give math at the same time, because we want to make sure that the student's English level is where it needs to be before they take the math placement test. Okay. We do accept TOEFL. This is the only English test that we accept. So if we have a student that has TOEFL within the last 5 years, then these are the cutoff scores where the student does not have to take our EFL placement test. They would take our math test and do a writing sample for our EFL advising office. And this is just talking about earlier, how do you know who should do the international application packet? And I'm going to I can make copies. This sheet here just pretty much give you an overview of who can do the international application admissions. To know if what a student's immigration status is, you can go to the FPER screen. If you have access to FPER, if the student is a permanent resident, the only time this screen will be blank is if they're a U.S. citizen. If they're not a U.S. citizen, there should be something in this screen. So you'll either see permanent residence, you'll see F1, you'll see L, you'll see undocumented, no visa, but that would be the screen if you wanted to know the student's immigration status. Okay. What students are eligible for in-state versus out-of-state? And that was the slide that we had earlier, which has this chart, and it lets you know who is in-state or out-of-state. If a student is coded out of state and wants in-state tuition, what are the procedures? Basically, they would have to do a residency application and submit that application along with supporting documentation to the registrar's office. And the registrar office determines whether the student can get in-state or out of state. If you want to look at the screens to see if a student is coded in-state or out of state, you can go to ASPR or SASM. And you would see here where it would say in-state and out-of-state for the student. What should I know when advising an F1 student? So every F1 student has to maintain at least 12 credit hours the entire semester. So the student registers for 12, the student needs to end with 12 credit hours. The summer semesters are optional for F1 students. If they want to go, they can, or they can choose to take off or take as many or less courses as they like. Online courses. F1 students can only take one online course per 12 credit hours. So if the student wants 2 online courses, he or she has to be in 15 credit hours. Immigration only allows 1 online course because from their point of view, if you're going to take online courses, you can take it from your home country. If you have an F1 student that wants to repeat a course and you're their advisor and you are recommending for that student to repeat the course, the student still has to come ask permission from me. What happens is because one of the immigration regulations, you have to make progress towards completion, I cannot justify extending the student's I-20 because he or she continues to take courses over and over again. So even if you may tell the student, okay, you need to take this course over again, that student has to come talk to me, and I would either let the student know that he or she can take it within the 12 credit hours, or if they have to take 12 credit hours plus that course again. Just keep in mind, it is the student's responsibility to know their immigration regulations and not the advisors, and it's their responsibility to maintain their status. So at the end of the day, it's really not your responsibility to remember what he or she is supposed to be doing. Okay. Student says he is unable to get 12 credit hours because all the courses are full. He mentions that he will be deported or needs 12 credit hours for his visa. How should I advise the student? If you working with a student and the classes the student needs is full, you can make recommendations on other classes. And if the student keeps saying, well, they're all closed, then you just tell the student to come see me. Because at the end of the day, immigration regulations, you have to be in 12 credit hours. I'm going to wonder, why are the classes full? Because did you wait to the last minute to register? Because if so, that's a problem. All right. So if you don't have to go back and forth with the student, if you know the student is F1 and that student said, well, they're closed, I need 12 credit hours, be like, okay, this is your list of classes. Here are your other options. If you need more guidance, go see Princess.
I think the challenge, sorry. I didn't raise my hand.
I know. Go ahead. She wants you to go.
I'm an instructor.
Mm-hmm.
I don't advise entry.
Mm-hmm.
I've had a student bawling her eyes out, saying that because she's failed my course, she's going to be kicked out of the country. How do I know if they're pulling my string? I mean, I don't change anything. If they
Right.
fail the class, they fail the class.
Right.
But how do I know if they're just pulling my strings or if that's a true statement?
Call me. I have curriculum instructors, especially ones I have a good relationship with. If they have an F1 student in their class and they're having problems, they will send me an email quick. And I love those emails. Because when that student comes to me, if 9 times out of 10, their story doesn't align with what the truth is. And so it helps me for you to reach out to me and saying, okay, heads up, this student has missed the max number of days. Because when that student comes to me with whatever reason they have, I already know you missed too many days. If you have a student that's failing and the student comes to you and say, if I fail, I'm going to be deported. Be like, okay, let me speak with Ms. Solomon. Call me or email me. I get the calls all the time. If the student fails 1 or 2 courses, they're okay. If I have students failing courses back to back to back to back, it will be a problem when it's time to extend his or her I-20. Because then I'm going to look at your transcript, and if you have 5 courses you fail, I can't give you more time to study. So 1 or 2 here and there is okay. And I'm pretty sure, I think a student has called me. So, but just pick up the phone and call me.
Well,
Email me.
Of course, the story was, this was after the final exam. I never knew she was an F1 student. She never talked to me about how she was doing bad in the course. It was just, boom.
At the end.
I was going to pass her. It's like, no.
No. And I have students come to me, because a lot of times they come to me and they say, I'm failing the course, I want to drop it. No. I don't allow students to drop below 12 credit hours just because they fell in the course. So what I tell them to do is go back and talk to your instructor. Find ways and resources how you can pull up your grades. Go to the ILC, because you can't drop a course just because you're failing it. Why are you failing it? If you didn't just finish EFL courses and you've been in curriculum courses for a while, I'm sorry. But yes, please reach out to me if you do know the person's the F1. Or I have sometimes where students go back and talk to an instructor and say, you know, I can't be dropped from this course. If I'm dropped from this course, I'm going to be deported. And then the instructor just call me or email me and say, is this true? And I email back with a blank statement, which, you know, yes, if the student is under 12 credit hours, what actually happens is I terminate the I-20. And then the student has a couple of options. You can either return home or you have to file for reinstatement with immigration. You can file for reinstatement 2 different ways. We can send paperwork to immigration and you have to explain why you withdrew from that course. And immigration makes the decision whether they give you the F1 status back or not. Or the student can take the risk, receive a new I-20 from me, and if his or her visa is still valid, take the risk of leaving the U.S. and coming back. The only problem with that is at the port of entry, they may recognize the previous record and that it was terminated and question the student, what happened with that record? And then it's left up to the port of entry if they allow the student back into the U.S. or not. If the student arrives back, then he or she has reinstated him or herself. So it is big consequences for the student if they fall below 12 credit hours. Okay, you go.
Actually, I have 3 things. One, are you included on the Starfish? What is it?
I have not.
Yeah.
I have not used it.
So
I'm
you're
pretty
not,
sure.
Like, alerted if we do something online, like if a student has low grades? Because I know it goes to student services.
I don't think so.
Okay.
I may need to be on there.
Well, that's good to know, because that way we would know we have to send
Right.
those.
I might need to talk to someone because I may need to
Um,
be on there.
2, if a student is, the challenge I have is having students get 12 credits, and it's not because the classes are closed, because it's not a cohort program, so eventually they end up where they've taken their gen eds, or they've had other programs. They might have been a pre-health science program, and then they were taking human services, so now they signed up for mine, and then, so I feel like I do creative accounting, because at times, so I have one student who has graduated. She's actually in 3 programs, and now she's working on her Associate of Arts. So she graduated 2 of my programs, and now she's in her Associate of Arts. But the other issue is about internships. So I've gotten different information about if a student who has an F1, how do we go about them doing internship, and when can they? And then also, once they complete the program, they look to us to help them stay for continuation for the next year in the state through like employment, even if it's voluntary.
Okay, so your question is internship for F1 students and employment after.
Can they do that, and then employment after? And then can they be in 2 or 3 different programs to get that full-time 12 credits?
Okay, and can they be in multiple programs to be 12 credits? Okay. The program that I find the most where students have to be in multiple programs to meet 12 credit hours is health science programs, because of meeting the requirements. So yes, they have no choice because they have to be in 12 credit hours. They can't not. So the health science students are in multiple programs, and that's fine. Internships, if work-based learning has to be a part of the program. If that work-based learning course is not a course that's involved in the program, then they cannot do internships. They can on a volunteer basis, but they can't get paid. So volunteer all day long for F1 students. But as far as work options, internship, work-based learning has to be a part of the program, a required course. So when the academic advisors say, okay, you're eligible for work-based learning, and the work-based learning office approves it, and they're registered in the the work-based learning course, then that student can do the internship part-time during the semester or the dates of that course. And so once all that stuff is processed, then the student comes sees me with their work-based learning paperwork, and I note the CPT on their I-20. But it has to be work-based learning is a part of the program. If it's not a part of the program, they can do it on a volunteer basis, but it doesn't refer to clinicals because that's part of the program. Your other question was after they graduate. After each F1 student graduates, they can apply for OPT, optional practical training. And that's where they're asking immigration to be able to work for 1 year to get work experience in their field of study. So we have to send off paperwork to immigration their last semester, and then immigration determines whether they're going to approve that employment option or not. If it's approved, then the student can work full-time for the year after graduation in the field of study, but the student still has to find employment just like anyone else would.
Does it have to be paid?
Yes. Because if the student, well, not necessarily have to be paid, because I will accept volunteer positions. If the student is unable to get employment, then they have to send me something, because I don't want their status to be terminated by immigration because they're like, you're supposed to be working and you're not working. So if a student is unable to find employment, then I tell them to volunteer part-time 20 hours a week somewhere and give me that information to report to immigration.
I just want to mention a comment. We were talking about what can be done for the students who are struggling, and that's kind of the reason why you're here, and the Global Forum is here as well. And you know, we have the Global Forum have a very big picture of how can we help a lot of students at one time, where you're very much, I mean, if they're having individual problems, they need to go to you. But there is this kind of a team effort, at least in this division, I think is important to know.
Right.
And please send them to a lot of the programs that are being offered through Global Forum too, because that can help them as well.
Okay, thank you.
What happens to the students after the year is up?
They either have to go back to school, so they either can come back to Wake Tech for a new program, transfer out to a university for a new program, or return home. And if they qualify for a different immigration status, they could possibly change to that status. But that's where they would have to contact an immigration attorney to see if there are other options. Another thing would be a lot of times students would try to find an employer that sponsor H-1B, which is an employment visa. You have to have a bachelor's for that. So a lot of the students, once they have their associate's degree, already have a bachelor's in their home country. So they may go to Duke or someone and work for them for 1 year and then contact them about sponsoring them for H-1B. There's not a lot of companies out there. I don't know which company sponsors students or not. That's something that the student has to research and find out which companies offer the H-1B or not. It's kind of hard if the student doesn't already have a bachelor's degree, but that is another option. A lot of students try to seek for that option. Okay. Right.
Can I ask a quick question too, when we're talking about the H-1B? There's times I've had a student at the very end and they just say, I need to get my working papers, and I don't know what that means. It's a broad term. Is that this? What is working papers?
They would have to explain a little bit more, because if they come to you and just say, I want my working papers, I would ask, what do you, right, I would ask, what do you mean? They would have to explain a little bit more, because I don't know if you're saying working papers to work right now, or are you saying working papers to be sponsored as a H-1B? I would have to ask more questions, right? I'm just like you, it's not enough information.
The optional practical training, they get permission to work. That employer knows that, is that correct? And so they know it's a one-year thing.
Yes. So the employer, they may not know up front, but at the end, they will end up finding out, and that's why it's hard for a lot of F1 students to gain employment, because the employer is like, oh, you only can work for 1 year and don't want to spend the time or resources to train someone, and then they have to leave after a year. But yes, the employer would eventually find out. Mm-hmm.
It's still be a problem with some of the medical certifications. I'm thinking, because you couldn't take a student like that unless they had a.
You have to have a social security number to be in the nurse aid, so.
Yeah.
Well, and you're talking about for nursing, correct, for the nursing? Right. So for my F1 students, they can go into nursing. What happens is when it's time for that student to do CNA, they have to come see me. And I have to do a workaround to try to get that student a social security number. what happens is I ask for the student to, when you meet with an advisor and you know exactly when you would be able to apply for nursing, I need to know that semester, because we work backwards, maybe about 2 semesters. And then I try to do what I can to get the student a social, so that way he or she can sign up for CNA to be able to have it in time enough for the application deadline for nursing. It's worked out so well. I have one student now, she's still waiting, and I don't know what's going on. Immigration is kind of taking a little bit longer with the employment authorization cards. But I do work with my F1 nursing students to get them the social so that they can get the CNA to get into nursing. We wait closer to when they're going to apply for nursing, because they cannot work to keep the license up. So if I have an F1 student to say, oh, I have to do CNA for nursing, and they, in the beginning, I say, okay, hold on, find out exactly when you're going to be able to apply for nursing. I look to see what courses the student's taking, because if they're not taking those key courses I know to look for, we don't need to talk about it. Because I had a student who took CNA way too early, and because he could not work to maintain the license, it expired before he was able to apply for nursing. And so all the money he spent was going down the drain. So now I try to prevent it. Even though the student come to me anxious, I'm like, no, because I don't want you to end up losing the license by the time you are able to apply for nursing. So I do work with the F1 students. However, if they are not F1, I don't help, sorry. I had someone that was on an H4. She was pretty upset, but I'm like, unless you want to change to F1, I can't help you, because you have other immigration statuses who may not have socials, and unfortunately I'm not able to help them. But I do help the F1 students. Any other questions?
Well, kind of aside to that, what if they are F1, they are not going towards nursing, but they just want their CNA? Will you help them get a
No.
social?
No.
They have to be all the nursing.
Right, because at the end of the thing is, what do you need a social for? The social is only meant to work. The Social Security office would not give you a social unless it's for employment, because our social is, that's the only thing it's supposed to be meant for. As an F1 student, you're not supposed to be working. So why do you need the social? If it's not because of the CNA, or if you're, because I think your question was if they just wanted to take CNA. If CNA is not a part of your program, you can take it if you want, but you have to figure out how you're going to take it. Because I let students do continuing education courses outside of curriculum courses. So if they wanted to do CNA, you have to already have a social, which may be possible for an F1 student to already have a social. But if the student wants to do CNA and does not have an F1 visa, social, or is not going in pre-nursing, then no, I'm not going to help. H4 is, so when we talked about earlier, H-1B, which is an employment visa, that means that company has sponsored that person to come here to the U.S. and work for them. Their dependents, spouse and children, are H-4s.
And you just mentioned from continuing education courses, so if there's an F1 student, we don't, I guess, get into whether they have a social or not, because anyone can take a continuing education course.
Correct. So your question is, for the F1 students, not having social, does it matter for continuing education courses or not? No, it doesn't. It actually doesn't matter for curriculum courses either. It just mattered for nursing for CNA purposes, because for the CNA course, a social is required, and that's where the students have the problem. I pretty much went over this already. You can go to the next one. I went over that too. All right, so we actually work out of SEVIS, which is an immigration database. That's where we create the I-20, we maintain the I-20, and it's ran by SEVP, which is a part of the Department of Homeland Security. And this is how we pretty much stay in contact with immigration. This is how I let immigration know if the student is here taking courses or if the student has failed to maintain his or her immigration status. Okay, so this is just referring to basically when the student enters the U.S. on the student record, I am indicated, I receive an indication letting me know that the student has arrived to the U.S. Because once the student comes to the U.S., he or she has to come to our office. That's the first step, because that student has to let me know that he or she is here in the U.S. and ready to attend school. Some of the duties in the international office is we have to register each student in SEVIS every semester. We have to monitor the students throughout the semester. So I go in and I run a report to let me know how many credit hours the students are in. If the student is below 12 credit hours and I have not approved it, that student will get notification saying you violated your immigration status, come see me immediately. The students get 3 notices, 3 emails, 3 letters. If the student doesn't contact me, it's automatically terminated. If the student comes in to see me, I would ask what happened, why you're not in 12 credit hours. 9 times out of 10, the record is still terminated because you have to be in 12 credit hours. So the most things I get is missed too many days, didn't turn in my assignment, the instructor dropped me, was late, and things like that. So unfortunately, we have to monitor that. We apply for reinstatement for the students, OPT, economic hardship. And also for students that comes here in the U.S. and need to change their status, I help them with that. An immigration attorney would charge them over $1,000, and we do it for free. And I give immigration regulations. So when students come in, or future students or local contact come in, they may ask advice for immigration regulations, and I also do that. If you ever have an immigration officer contact you about a student, please refer them to me. And then I would determine whether we can give them information or not. And as I said before, in the office, it's myself and Zanita Evans. This is our contact information, so if you ever have any questions, you can feel free to give us a call. Also, our contact information is on our international website, international.waketech.edu. If you ever have anyone that needs information or advice about his or her immigration status, please feel free to give them my number. Just ask them to leave a message if I'm unable to answer the phone, or they can send me an email. It's no problem. I'll email back. Okay. I think you had questions, so I want to answer those right quick. I think I already answered. What does F1 status mean? That means that that person is here in the U.S. on a student visa, and their purpose is to be here and be a full-time student, 12 credit hours. The difference between a visa and a status: the visa is what's given at the embassy to allow the student to enter the U.S. The status is what the student has while he or she is in the U.S. So a student can have an F1 status and not have the visa and the passport, because the visa is only like the key you need to get into the U.S. That's all it's good for. Okay. So when I'm talking to someone, if you were to call me and say this person is here on a tourist visa, I want to know what their status is, because you can have a tourist visa and be undocumented. When you enter the U.S. on a tourist visa, you have a 6-month stay. If you stay past that 6 months and don't ask for an extension, you are undocumented. So to me, at that point, it doesn't matter what your visa is, it matters what your status is. So it's 2 different things.
And your status can only be documented and undocumented?
No. For instance, the F1 students, their status is F1. Someone here on a H-1B, their status is H-1B. Now, a person can be here in the U.S. with an H-1B status and not have the H-1B visa in their passport. So for instance, you have someone to come here on a tourist visa. They enter the U.S. with the B2 visa, and then they apply for a change of status to F1. Once immigration approves them, their status is F1. But they don't have the visa in their passport because they asked for a change of status here in the U.S. So your status means more to me than your visa does. And so we already talked about the H-1B sponsorship. You had questions about that. And we already talked about documented versus DACA. Any other questions? Anything you need me to clarify?
I have just one question. How many students who have political asylum or refugees are within
I don't know. As far as the number that I gave you, that's only F1. When I ran the numbers for, but this number did not include refugee or asylee. We have about 360 so, but that does not include refugee, asylee, permanent residents, or U.S. citizens. We don't keep up with that number. I could find out the number for you if you needed to know. We do have a lot of students with refugee or prodigy. Mm-hmm.
They're a unique population and need special attention, I think.
I can run a report to tell you which ones are refugees and asylees. Another population of students we have is students that come on special immigrant visas, and they actually are coming into the U.S. as permanent residents with refugee benefits. And for those students, they are not considered refugees. They are considered permanent residents. It's just the type of visa they have, they get refugees benefits in the community. But unfortunately, here at Wake Tech, you're a permanent resident, and it would fall under that. But if you actually come in the U.S. as a refugee asylee and you can show me your I-94 card showing that stamp, then yes, you get in-state tuition and everything.
They really don't have a lot to do with you then. Once you check them off, they're kind of like a...
For refugee asylees, correct. And the only reason they come see me is if it's questionable on their application. If they fill out their application right, I never see the student.
You must have some, though, that are in the process of becoming political asylum.
Yes.
That's a really lengthy process where they can't work for like 6 months or something like that?
Yes. Yes, so we do have a couple students who are pending. Their asylee application is pending, and unfortunately, well, they show me their receipt showing it's pending. I allow them to register, but unfortunately, they're pay out-of-state tuition because the application has not been approved. But the minute it's been approved, I tell the student, come see me with your I-94, and I change it to in-state immediately.
How does financial aid packages fit here?
Okay, so how does financial aid fits with F1 students? Unfortunately, F1 students do not qualify for financial aid. They have to show the financial documentation showing they're able to cover the tuition. For financial aid, you have to be a U.S. citizen or a permanent resident in order to qualify for financial aid. Any other questions? No? Okay, thank you. Thank you.